Okay, today is February 4, 2013. This is Children and Justice. So what did you think of the Galloway case? State versus Anthony Galloway. That's the shaken baby case. Or as they say now, abusive head trauma. We don't call it shaken baby anymore.
Well, I have questions with regard to the way they categorize certain crimes. And, based on the fact, and this is only my knowledge from watching television.
Well, did you listen to the lecture? You told me you listened to the lecture,
Yes.
right? Okay, go ahead. What were your questions?
I still have questions around the fact that why is it in the law that if a man admitted to killing the child, why was there a qualification as third degree or fourth degree? To me, based on the fact that he had said that he had intended to kill the child because, the child was from a rape, his girlfriend's rape, I thought, he had admitted so much it was like murder of forethought. So I was confused as to why there had to be a qualification in terms of degrees.
Yeah, well, the kinds of questions that you're raising, a lot of students have raised over the years, and that's why I put that message, as well as addressed it a little bit in class last week, but I put that message there in the learning module that said, a lot of students have a tough time with the Galloway outcome, and I don't blame them. But first of all, you mentioned that he admitted that he did certain things. You have to understand what Galloway is. Galloway, and we're going to get to this in a little while. This was an introductory module, but Galloway was an appellate division decision. So what happens is, there's a baby that's dead. An investigation ensues. Rest assured, Child Protection, DYFS at the time responded. Prosecutor's Office, Homicide Divisions responded. Was that an Essex County case? Does someone remember what, or was it South Jersey? Whatever community it was in, the division responded, the police responded, and the prosecutor responded. They conducted an investigation. Among the evidence was the deceased child. Among the evidence was the diagnostic opinions of the physicians, what the causation of the injury was. And in shaken infant impact syndrome, which we now call abusive head trauma deaths, the hallmark of that kind of child death, as many of you know, is cerebral hemorrhaging, or what we call hematomas, blood in the brain cavity, edema, swelling of the brain, which causes asphyxiation, and retinal hemorrhaging, and often broken ribs or other injuries to the bones, because shaken baby cases are about not only shake, but tossing or throwing, and the babies get injured after the shaking. So the doctors had to come to that conclusion. That's not a police job. The doctors looked at the baby. I assume they looked at the body scans, they looked at the CAT scans, and they concluded it was shaken baby. So that's part of the investigation. The police also spoke to Anthony Galloway. And the police say, if you ever asked a guy at the county jail or state prison, what did you do? This is what nearly all of them say. And I challenge you, if you ever have to go to the jail, you run into a guy who's in prison or is being prosecuted, say, what did you do? And they'll start this way. Nearly all of them. They say I... ... So Anthony Galloway, he probably told his lawyer, they say I told the cops I did this, but I didn't do it, or was coerced from me, or I only said half of that. They made it up. So, although the police said we have a confession or statements in the form of admissions from Anthony Galloway, when he went to trial, it is highly likely, now I haven't read the Galloway case from start to finish, I've never read the transcripts, but I'm pretty confident that he denied making those statements. And he probably asked for what we call a Miranda hearing, which we'll look at later, where he said that if I did make the statements, I made those statements without the benefit of being advised of my Fifth Amendment and Sixth Amendment constitutional rights. But I didn't make them anyway. But if I did make them, they didn't give me my Miranda rights. And if I did make them, it was coerced and involuntary. So at the end of the day, when that jury trial begins, He says that didn't happen. I didn't say those things. And the government comes in and says, well, you did say those things. Here's the police officer who claims you said those things. Here's the doctors who said that the baby suffered these particular injuries that are diagnostic, and tell us something about the mechanism of injury. That's the interesting thing about Shaken Baby. We can conclude with a reasonable amount of accuracy how this baby died. So all that stuff happened. He had his version, the government had their version, and there was an outcome. And he was convicted of murder. He was also convicted of, back then, third-degree endangering the welfare of a child, as well as probably assault and who knows what else. There likely was an indictment or a bunch of charges. Maybe there was domestic violence that day. I don't know what happened. I don't remember exactly the facts. But rest assured, there probably was more than murder and endangering. But they're two separate charges. Now, murder speaks to, and you talked about malice aforethought, which is an old-fashioned way to say it, but it certainly is understandable. That means you thought about it before you did it. That you had the mens rea, or you had the intent to kill the child. And, that would be murder if it happened that way. And if the government proved their case and the jury agreed, murder would be proven. But endangering addresses a different issue. Endangering addresses caregivers who commit acts upon people under their supervision. Children, rather, not people. Children under their supervision. And because endangering is broader than murder, nearly any kind of injury that's non-accidental, that occurs to a child because of the caregiver's behavior, is actionable under endangering. So you got murder. You use the term malice aforethought. Murder means you intentionally assaulted someone with the intent that they die. Malice aforethought. That's murder. Endangering the welfare of a child says, if you have a child in your care, either because of a legal duty or because you assumed a legal duty, and you cause that child harm that would make them abused or neglected under Title IX, you're guilty of endangering the welfare of a child. By the way, there's another form of endangering, and we had it on the big board last week on the screen. If you have a legal duty or you assume a legal duty and you engage in sexual conduct, not contact, conduct with a child, that's another way you can be an endangerer. Now, Galloway wasn't a sexual endangerer. He was a physical abuse endangerer. And if you look at Title IX, which we did last week, not for this proposition, but we looked at Title IX. Title IX is highly detailed. There's a lot of different ways to be guilty of abuse or neglect under Title IX. In fact, some of the theories of liability, some of the ways a person can be guilty of abuse or neglect under Title IX, which is still good law, involves the habitual use of obscene or profane language in the presence of a child, vexing a child. Now, I ain't met anybody recently who vexed a child.
That's why I laughed.
But I said something similar to a past class, and somebody was Googling it as I stood here, and they told me what it meant, and I don't even remember. But some of the things that you can do are what we call anachronisms. Anachronism is a word that means something from another time. You'll see that another way that someone can be liable for endangering is to employ a child in a profession which might be injurious to their mental health and emotional. You see, some of these laws were passed when kids worked in bakeries for 16 hours, but more likely when kids worked on farms and in an agrarian, a farming nation, or in a farming area. And parents would sometimes have their kids out in the field for way too long, and maybe make them at age 8 run a tractor or something. And that's the kind of things that led to that section of Title IX that deals with employing a child in an injurious vocation. I forget, I'm paraphrasing, but there's a section about that too. Of course, there's sections on sexually abusing children, assaulting children. We looked at the section that said an unjustifiable risk of imminent harm, whatever we looked at last week. There's a section there about, engaging in behavior that is a risk to the child, the kind of risk that might wind up in causing death, or does someone remember what else it said? Something like likely to cause death, or significant injury, or something even more
To allow the creation of substantial or ongoing risk. Is that what
yes. Keep going.
of physical injury to such child by other than accidental means which would be likely to cause death or serious or protracted disfigurement.
There you go. Serious or protracted disfigurement. So endangering, you can be guilty of physical harm, causing physical harm, by doing things that are rather obvious to us. Battering a child, shaking a child to death, punching a child, beating a child. Those are obvious. But there's other ways one can be liable under endangering as well. Many of them aren't the subject of DCP&P investigations and interventions anymore, nor prosecutions. But every now and then we try to plea bargain a case out in the criminal system. Maybe the guy will plead guilty to cursing in front of the child. Everybody is able to walk out of the courtroom having got something. But it really is not something in the modern era that we utilize too much in either child protection or criminal law. So back to Galloway. This is a murder case. Galloway murdered the baby. Okay? But he also was charged by the prosecutor in that jurisdiction with endangering. And the prosecutor's theory was that he was responsible because he was mom's boyfriend and had a presence in the home and had assumed responsibility for the care of the child. And he was convicted. You're reading the appellate division decision. He was convicted. The jury agreed, the judge agreed, the prosecutor agreed. The only one who didn't agree was Galloway. It went to the appellate court. The appellate court reviewed the entire case, and then they wrote the opinion you read. They said, well, and Galloway's lawyers passionately argued that he shouldn't be responsible under third-degree liability. And they won eventually. They said, look, the beginning of endangering starts out with someone who has a legal duty to care for a child or has assumed responsibility. So there's that disjunctive there. There's that word or. And they said the second part, having assumed responsibility, has to be really meaningful to be the equivalent of the first part. People who have a legal duty are really important people who have enduring and long-term and sacred responsibility to care for a child. Parents, teachers, jail guards, people who are given absolute custody and control over children. And the second part says, or someone that looks like that, so to speak. Someone who assumes such sacred responsibility. Well, the guy who says, what's that? You want to run down to ShopRite to get a quart of milk, man? I'll keep an eye on your kid. That doesn't even reach close to the legal duty kind of people. Now, we're not looking at this informally like what parents' expectations are. I leave my kid with somebody, I expect they're in charge of them, and they assumed responsibility. But from a legal perspective, the appellate division, whether you agree or not, appellate division said occasional caregiving, once in a while, doesn't reach, that sacred relationship, that really meaningful relationship. Therefore, it should be treated less harshly. Doesn't mean that Galloway even beat the endangering. And it hadn't. It was really, Galloway's still in prison. That was a minor skirmish, legal skirmish he won, and it was a distinction without merit because he was convicted of murder. Murder's 30 years to life in New Jersey. But for the future, it set a precedent for how we treat endangering cases. And his argument was that I'm not that involved in that kid's life, and I really didn't assume responsibility. I wasn't the meaningful kind of caregiver that the appellate division is talking about. So Galloway didn't beat the case. He simply was found to not be guilty of endangering someone who he had a special supervisory, caregiving, sacred relationship with. He killed his once-in-a-while girlfriend's child. And I don't mean to demean or diminish the seriousness of what he did, but that's what he did. And that's what Galloway is about. And that's an example, and that's what your discussion board was about, and that's an example also of what your learning module 1 was all about, the nature of language in the law. and how nearly all language is ambiguous or capable of multiple interpretations. And even when it feels and seems concrete, language is still capable of being misunderstood or having a different interpretation than most people think. And that's the basis upon which we start this course, realizing that language is important. Whether children get justice in the courtroom sometimes turns upon the words of the law and people's interpretations of those words. And there was some good discussions in the discussion forums about those kinds of things. And because this is a class of many child protection workers, not all of you, you've had some personal anecdotes, and some of you, I'm sure, have had your actions scrutinized by appellate courts and supervisors and said, well, it doesn't fit that. Well, it seems like it fits that definition to me. Well, that's not what the courts have said. I mean, there are a bunch of cases from 2004 till today from the appellate division that attempt to redefine neglect. I mean, there's some 2 or 3 cases where the commissioner and the deputy attorney generals representing child protection, argued emphatically that these things were neglect, and the courts didn't agree. And, there was one case where 2 children were at a condo community, and they were by a pool that was part of the condo community. And they were with mom, and the children went back to the condo to do something. I think they squirted each other with water bottles, and the kids they had to get changed for some reason. And when they got back, now the ages are always important, I don't remember, but I'm going to guess it was somewhere about maybe 7 and 5. When they got back, they went in the condo, they did whatever they had to do, and when they tried to leave, they had one of those child-proof doorknob thingamajigs. And they couldn't get out, the children. And they panicked, and they freaked. But they had a hardline telephone. They dialed 911. The cops come, where's Mommy? I don't know, by the pool, whatever. Found Mommy. Now, the court was like, well, you have to leave the apartment, and you go, and there was always a line of sight. Courts are really big on lines of sight. Because there's another left in the car case where the mother, the caregiver, beat it too, because she was like, well, she just ran in to try on clothes, but she always had a line of sight, which this was an outrageous decision. But you know what? Nearly all these cases start out with Mrs. Jones, who's a pediatrician, or Mrs. Johnson, who's a vice principal. If you don't think it's about class and race and all that stuff, it still matters, sadly. And I always wonder why that's the opening line of these cases. In any event, we're not going to focus too much on that. What I want to focus is on language. And the word neglect, it's a word that's capable, obviously, of multiple interpretations. And that's what the law does, and it's okay to do that. We need to analyze things. And an accident is an accident. Every one of us in this room is capable of doing something accidental, or even making a mistake, or doing things that you regret and you would have done differently. Does that make it neglect? Does that make it criminal neglect? Does that make it actionable child protection neglect, where your name gets in the central registry? That spelled trouble for the division or for DCP&P. Once they created that central registry, the courts started to scrutinize everything because they felt that created a significant disability in the general sense to people having jobs, being foster parents, and doing whatever. That this thing changed the ball game of parenthood. And if you're going to do that, you better be sure what you're doing, and we're going to scrutinize these things. And they do. They do. And that's why there's a bunch of appellate division opinions in the past 6 years that are critical of child protection's interpretation of abuse and neglect. Any other comments on Galloway or any of the definition stuff? I end it with state in the interest of MTS, and that was the case that interpreted the definition of force or coercion. Some of you mentioned that in the discussion forums and talked a little bit about MTS, which is a fascinating case. And what's so interesting about it is, in part, not only that the Supreme Court interpreted what force or coercion meant, but they went through a few hundred years of sexual assault law, going back to how rape and carnal abuse was interpreted in England, which was the source of much of our early common law in this country, and even the laws on sexual assault that survive today. And at the end of the day, the Supreme Court of New Jersey issued a very progressive ruling, and as you recall, I said force or coercion means when a person does not have the freely provided and affirmative permission of the other person. So I'll talk in man-woman context, it's just easier. When a man does not have the woman's freely provided and affirmative permission, that means in New Jersey, the woman has to say yes. Now, that doesn't mean you need a contract, right? It simply means that you need to point to behavior or context or language. They could say yes, but that's not the way the world works, right? It would be rather sad place if we needed to get the specific, affirmative, verbal permission from our intimate partners for every aspect of our interactions. Because you can say yes to fondling of the breasts, but not fondling of the vagina. You could say yes to the fondling of the breasts and the fondling of the vagina, but you could say no to penetration. Jurors don't like that, but theoretically, one needs permission for each specific act of sexual contact. The good news is we don't parse those intimate relations to that extent, even in New Jersey. Although the defense lawyers, when that case was decided, suggested that that was the bleak world of romance that the Supreme Court was ushering in when they made a decision. And I'll tell you what, it never happened, and it's a good law, a good interpretation of the law, because it allows a lot of flexibility for charging. And most of these cases, if you look at the victim's perspective, and if her version, it's typically a woman, but sometimes men, is 100% correct, this is not something that's a close call. It is exploitive and assaultive. The world that the defense lawyers feared never arrived. Because you have to proceed and convince a jury with these cases. So if it's close, you're not going to go to a jury if you're a prosecutor. I mean, you have to have a reasonable shot of success if you're going to go to court. But what it does do is it opens up the opportunity for plea bargaining. It protects victims, mostly women, from having to object or fight back or defend their behavior. You don't have to defend your behavior anymore. Because if, as the Supreme Court said, and I'm not saying it quite as eloquently as they did, but if the analysis is on the victim's behavior, right, then we begin to judge everything they did, right? But it's not on the victim's behavior. The suspect has to point to reasons why the victim consented. Hello? So, that is stated interest of MTS. Force or coercion. We are a say-yes state. That's the way I like to express it. Where Pennsylvania is a say-no state. The victim has to communicate no. In the absence of no, it's yes. In many states. New Jersey is among the most progressive. But jurors still have, they're tough cases to prosecute. But they help us with what are called acquaintance rape cases, date rape cases, college campuses. You get these kind of situations this weekend here at this university, and next weekend, and the weekend after that. In that murky world of sexual contact and behaviors that go on campuses. You get more than your fair share of sexual assaults that happen here. Not only here, throughout America on college campuses. And MTS made it a little easier to get into the courtroom in those cases. So we're going to move on to Learning Module 2 now. Okay, Learning Module 2. Who still doesn't have the textbook? Okay, who hasn't ordered the textbook yet? Got to order the textbook. I'm trying to find copies for you. Anyway, you have to read Myers, and Myers is going to be on the exam, so, you've got to find them. And that's pages 43 to 68. It's up there on the board. Now we're going to start out by talking about bail, the purpose of bail. Now, it's interesting to think about a system that requires people to give the government money in order to stay out of jail. There seems to be something wrong with that. It seems to be it seems to create a mercantile or commercial aspect to the legal system. I mean, the legal system is supposed to be about fairness. The legal system is supposed to be about who follows the rules and who broke the rules. Why would we have a system where people who have cash, people who are able to give the government money, get to stay out of jail, but people who don't have the money or don't have enough money have to sit in jail? Well, unfortunately, it can have a disparate impact upon people who don't have the means to post bail. The rules governing bail in New Jersey and throughout most of the country require that the court take into account the person's means. Because at the end of the day, bail is about one thing and one thing alone. Bail is designed to give the defendant an economic stake in the outcome, in the proceedings, in the process. And what I mean by that is, the purpose of bail is so that someone accused of a crime shows up in court throughout the proceedings. Bail is set as soon as someone's arrested in this country. Bail is set when someone is accused of a crime. And it's designed to make sure that that person shows up to court. Now, for a long time, New Jersey did not allow bail for preventative detention. Many states do, and the federal government does. And we're going to keep proceeding under that theory. I don't believe that the law has changed yet in New Jersey, although they're thinking about it. I think there's a clip on your learning module. Let me see if it's here. Did I put it here? Where Governor Christie's talking about I'm not sure I put it there. About permitting bail to be used for protection of the public. But bail's not designed to protect the public. Bail's designed for one reason, and that reason is to make sure that they show up in court. And the assumption is that if you have money placed with the court, that you're less likely to flee. You'll hear terms like flight risk. Whether the accused is a flight risk. The more likely the accused might flee, the higher the bail. Bail should be proportionate to the flight risk. By flight, we mean run away. Now, there are a number of factors that the court utilizes to determine whether someone's a flight risk. This is the statute in New Jersey, the law, that tells us what to look at when setting bail. Well, the first thing you'll see on the board is the seriousness of the offense. Now, we look at that not because we want to keep the serious guys in jail because they might hurt other people. That would be preventative detention. Word preventative, right? Prevent. Detention meaning keep locked up. We don't set high bails, at least on the surface. We don't set high bails to keep bad guys in jail so they don't hurt other people. And the reason is because these people under our Constitution, under the American system of jurisprudence, are presumed innocent. So if they didn't do it, or we don't know whether they did it, what are we protecting the public from? Nevertheless, the seriousness of the crime is significant, because if the purpose is to make sure they show up for court, then it follows that the more serious the crime, the more likely someone might flee. Does that make sense? If you're charged with running a stop sign, are you going to take a plane and move to Algiers or the Republic of Northern Ireland because you, God forbid, if you get convicted, I got to get out of here? No. A de minimis crime, a crime where the outcome is not that serious, you're not going to flee. On the other hand, if you're looking at a capital offense where someone may go to the gas chamber, which has been abolished in New Jersey, but some states still have it. If you're in Texas, you might be executed. Well, you're more likely to run, right? In fact, in Texas, there might not even be a right to bail in capital cases. But let's bring it back to New Jersey. New Jersey, for Anthony Galloway, the penalty is 30 years minimum, life in prison without parole maximum. So a guy who's charged with an offense where if you lose, you might wind up in jail for the rest of your life without parole is more likely to flee than someone who spray painted the back of a business on Main Street and was charged with graffiti. Right? So the seriousness of the offense is important. But only on the basis of how it impacts that guy's desire to run away or not. You understand? We're not putting, well, he's a murderer. He could murder other people. Galloway could shake other children to death, keep them in jail. That's not the analysis. The analysis is Galloway might run because he knows if he loses, he's going to be in jail for a long time. So the higher the stakes, the more likely you're going to run away. So goes the theory. So that's number one. Number two, criminal record, if any, and previous record on bail, if any. So a person's criminal record's relevant. Interesting. And their record on bail, if ever on bail. Let's put the bail issue to the side for a moment, prior record on bail. Let's look at the criminal history. Why would a person's prior criminal history be relevant to whether you're going to take a chance on letting this guy or gal stay in the community until the trial's over? What does that tell us about a person, whether they have a criminal record or not? Well, that's
They may commit another offense while on bail. They may get in some more trouble while they're out on bail.
no, that's not why we look at it, though. But I understand what you're saying. Remember, let's go back to the purpose of bail. What's the purpose of bail? Make sure they come to court. We're trusting someone, right? I try to analogize it. If you're going to lend $1,000 to somebody, you don't know them very well, right? Imagine someone wants to borrow $1,000 from you. And you know them a little bit, but not well. They want to borrow $1,000. You would want to know a little bit more about them, right? You would want to know whether they borrowed money in the past. And they paid it back. How long they took to pay it back. Were there any problems in the past? That's analogous to the second part, right? The prior record while out on what? Bail. So if there's a history of the guy that we're going to set bail on, being on bail, right? Let's see how he did on bail. Did he show up for court? Was he late? Did he get charged with bail jumping in the past? the prior record on bail would be relevant. Just like if you wanted to lend $1,000 to somebody, you want to see what their prior history of paying back debts is. Bail is about trust. Bail is about whether the word of the person that they're going to come to court, okay, is meaningful. Whether we accept that. Whether we trust what they say. Same person you want to lend $1,000 to. Right? Call it Johnny A. You're going to lend $1,000 to Johnny A. You know him a little bit. He's a friend of a friend. Seems like a nice fella. Right? Pay back his debts. He borrowed money from another friend of yours, you heard, and paid it back in a timely fashion without any problems. But he's got 2 prior criminal convictions. Might that affect your thinking about whether you're going to lend him money or not? You may still lend him money, but would that matter to you? You'd be like, hey, I don't care about that. I just want to know if he pays his debts. Would any one of us in the room say, tell me more? Well, what kind of criminal convictions? What did he do? Why does it matter? Why does a criminal conviction matter? It's about trust, right? Bail's about trust. Is someone who commits a crime less trustworthy, less likely to live up to their word than someone who doesn't commit any crimes?
No,
Not necessarily. So you would quickly give the $1,000 to the guy who's got prior criminal record?
No, but I wouldn't quickly give it to anybody. Honestly.
Well, let's say that you were going to lend somebody money.
I mean, honestly, if I had the choice, of course, I would give it to the person who didn't have the history, but that's because of, our preconceived notions that people that have been in jail are bad.
Well, let's think about it this way. We have a set of societal norms, right? There are rules of behavior in our state. We hope that everybody lives up to them, because when people don't follow them, it sometimes impacts other people, right? And we pass a bunch of laws, and we put them in a book called the Criminal Code. Right? And when you violate that, you violate societal norms. You don't care to follow the rules like everybody else. How much weight you give that? You might give it a little weight, no weight, or a lot of weight. Right? You'd want to know more about the criminal offense. But at least one level, they violated the trust of all of us. We live by the rules. This person didn't live by the rules. Now, maybe they were falsely accused, but they pled guilty anyway. Maybe they were mistakenly convicted by a jury. Possible, but like anybody else, you want to know more. The worse the record, the more criminal convictions, the more likely that person's untrustworthy. And if you think otherwise, then lend some money. Feel free to lend $1,000 to some dude who's got 11 criminal convictions, 2 for armed robbery, 1 for burglary, and 3 domestic violence. Go ahead, lend him $1,000. See whether you get your money back. Maybe you will. Maybe you can argue all that behavior as unseemly and as despicable as it is, got nothing to do with whether somebody pays money back. This is not the thing the court focuses on completely, but it matters. It matters whether somebody doesn't follow rules, because we're giving you a rule here. Show up for court. If you couldn't follow society's rules, then it's possible, it's more likely compared to someone who does, that you won't follow the rule of showing up for court. So we look at whether someone has a criminal record and the extent of that record. And like all of you suggested, I think, I want to know what he did. There are certain crimes that are more helpful than others. Right? Bail jumping, well, that's a crime that's directly relevant, right? In fact, that has to do with the second part. Their record when they were on bail. What is the most persuasive to judges, I think, are crimes that involve veracity. Does someone know what veracity means? Truthfulness, thank you. Truthfulness. Crimes that involve lack of truthfulness. You don't get charged for truthful behavior. Fraud. Theft by deception. Right? these kind of offenses are more meaningful if you're setting bail, right, than an assault. Somebody got in a fight in a bar, or arguing over a loved one, and they get charged with assault. Or even some other offense. But when you have an offense that involves fraud or dishonesty, that cuts right to the heart of what we're talking about here. Is this person trustworthy? If they have a criminal conviction, for credit card fraud, and they have another criminal conviction for perjury, it doesn't get much worse than that. What's perjury mean?
Lying.
Where? In court. That's a guy that's going to have a high bail. Right? Should have a high bail. So why we look at convictions, we need to get behind them. Some of you express concern, well, there's a lot of different stories and a lot of reasons why, and that's true. So we look at the nature of the offense. We look at the offense on one level, because any offense is a breach of the public trust. But we also want to see what kind of offense it is. There are people who get charged and people who have problems with criminal law that are honest, hard-working people, and they had a problem. Maybe early in their life, maybe they had drugs involved. Maybe it was some other issue that was explainable. But you still need to look, right? So we look at that. We look at the criminal record. We look at the seriousness of the crime. We look at their prior record on bail, if any. Now we get into these kind of wishy-washy areas, the defendant's reputation. Now, if you can't get 2 or 3 people to say nice things about you in this world, bail is the least of your problems, I think. But there are people who come in and people vouch for them, and that's okay. Courts listen to that. If I had a nickel for every pastor that came in that spoke on this young man's, and I always go, how long have you known him? He came to my church 6 weeks ago. I embraced him as I embrace everyone. And you know what? I respect the pastor. God bless, there's people like that in this world. But, that doesn't tell us a lot, does it? He's not bad. I want to know the guy he grew up with. I want to know what his girlfriend says about him. I want to know what his buddies say about him. I want to know, what people say about him in his community that know him. But the reputation is relevant. The mental condition, you want to make sure that the person, is able to comprehend and process and understand, what the obligation is to come to court and to resolve this matter. Obviously, any mental health issues that impact upon that awareness or impact upon the general responsibility of the person are important. The length of the defendant's residence in the community. Well, that's important. It matters. It matters. Primarily because a person who's lived in the community for a long time has roots in that community. We call that roots in the community. Again, that doesn't mean that some transient people automatically can't get out of jail. But if you compare 2 people, right? You compare someone who's lived in Passaic County, or Essex County, or Middlesex, wherever, Warren, Cumberland, Gloucester, wherever you are. If you would come to court and say, Judge, my client, Johnny A., has lived in Essex County his entire life. In fact, he went to the Hillside School on Hillside Avenue in Livingston, went to Livingston High School. When he got out of high school, he got a job right here. He still has a job here. He works at AAA Auto Mechanic on Northfield Avenue. His brother Anthony, he owns a bakery down on Mount Pleasant Avenue. His mother and father are hard-working people. Their parents lived in Essex County. He's got roots in the community. Now, someone else gets charged. Same judge, same crime. Judge says, where are you from? Well, I'm staying in West Milford. How long have you been in West Milford? A couple of months. Where were you before that? Galveston, Texas. What were you doing here? Making pizza pies. How long did you live in Galveston? About 6 months. What about before that? I lived in Tampa. How long did you live in Tampa? Oh, a long time. How long? A year and a half? Oh, what's your... I was a waiter at Tampa. Okay, where before? So you see what I mean? There's a guy who's, they call that transient. He gets around, right? He doesn't have any roots in the community. Now, we're not judging these people. We're not saying he's bad. In fact, that life seems kind of fun to me. But he's a flight risk. The question you have to ask yourself is, what does the defendant lose if he runs? Johnny A., everybody's in town. All his family's here. This is his only thing he knows. Now, he may still run, but he gives up a lot. You know, the character who lived all over America, he ain't giving up much. Right? So again, we don't judge good or bad. We just judge flight risk. And the guy who's transient, the guy who, wherever he lays his hat as his home, is more likely to flee because he's less likely to have an investment in the community and to stay. Okay? Family ties and relationships, I just covered that. Employment status, record of employment, I just covered that. Financial condition, the ability to pay. The pastor who would vouch for him. Any other factors indicating the mode of life or ties to the community, or bearing on the risk of failure to appear. And the general policy against unnecessary sureties and detention. What that means is unnecessary bail. We'd like to have everybody out on their own recognizance. Being out on your own recognizance means you don't have to put any bail. If you watch those television shows, Jacqueline, which person? Pamela. Pamela likes the cop police shows. Some of them I like, most of them I don't, but I do. I like Law and Order.
I like Law and Order. Those are the basic shit I like.
But you'll hear, Judge, we're asking for ROR bail. ROR. Released on recognizance. Recognizance, another word from England, some leftover word, an acronym from another time. I don't even know what it means. You can Google it. Tell me what it means. The actual word. But I know what it means to be ROR. ROR means I don't have to put up any money, but I promise I'll be back. ROR is a promise. I'll be back. Trust me. Later. ROR. R, released. O, on. R, recognizance. Or your own recognizance. And that happens sometimes.
Isn't it meaning responsibility, or you're willing to take responsibility?
Oh, recognizance? Well, yeah, that could mean that. Yeah. Yeah. Well, let's look it up.
I'm guessing.
No, let's look it up. That kind of makes sense.
A conditional obligation undertaken by a person before a court. It is an obligation of record entered into before a court or magistrate duly authorized, whereby the party bound acknowledges that they owe a personal debt to the state. A recognizance is subject to a defensive? I don't know. That is, the obligation will be avoided if person bound does some particular act, such as appearing in court on a particular day or keeping the peace.
So what is that? Wikipedia? Yeah, that's okay. Yeah, it's an obligation. Released on your own obligation. But
Yeah.
it's a promise you'll show up without having to put money up. You don't have to put money up. You're released on your promise to show up. Now, there's a number of different ways that the courts express what the bail is. I'll discuss in a moment, but I want to talk about these any other factors here. What are some other ties to the community that people have? What else keeps people around? You know, some people, they born, they live, and they die, and they never leave wherever they grew up.
Social.
And that's okay. Social relationships, right? You've got friends and neighbors. This is what makes life, right? You're people. Things you do. You hang out, you wake up in the morning, you go to work, you come home, you spend time with your friends and relatives on the weekend, you have children, right? These are the things that are important to people. And to run to Algiers or Northern Ireland or wherever they go that they don't have an extradition treaty, you give it all up. So those things are important when we assess bail. Now, compare two people. Person rents, person owns a home. Who's more likely to flee? The renter. Look, we're not judging the renter. It's okay to be a renter, but they don't have an economic stake that the owner has. That's one factor. There's a lot of factors we look at. We're going over all of them. But obviously renting is different from owning. So if you own a home and you own a business in the community, you're going to be giving up more if you run. Therefore, you're less likely to run. Again, it ain't about good or bad. It's just about likelihood of running away. Very few people run. So all this bail. Surprisingly, people that are in really, really hot water don't run that much either. Rarely run. For the reasons we're talking about. Where are you going to go? And a lot of these people convince themselves they're going to beat it. Even if the evidence is overwhelming. They're going to beat it. Hope springs eternal. But at the end of the day, if you're going to run, that's a bold move, man. For the reasons we're talking about, you got to give it all up. And that's a tough thing to do for most people, right? Go to Casablanca, perhaps. So we want to look at the whole person when we decide these things. Now, the forms of bail. The easiest one is money. Now, if you were charged, if a person is charged with, let's say, second-degree criminal assault, that is the infliction of or an attempt to cause serious bodily injury to another. If you're charged with that, remember we talked about second degrees, you get 5 to 10 years in jail. Okay, on a second degree. So if you're charged with criminal physical assault, not sexual assault, second degree, the court's got to make a decision straight up on what your bail is. Are you going to be released on your own recognizance, or are you going to have bail set in a monetary amount? They're going to go through this analysis that we just talked about, and they're going to set bail. So if Johnny A is charged with aggravated assault, the judge can set bail anywhere from $100 to $100 million. But let's say the judge sets bail at $35,000. Now, what does Johnny A do? He has to come up with $35,000 and bring it to the clerk of the court, and they'll put it in an interest-bearing account for you at the prevailing rate, which is probably 0.001% these days. You know, I don't even know if they put an interest-bearing account. That's a good question. I think they do. I forget. But they're going to take it and put it in escrow, right? They're going to hold on to it on your behalf. And when the case is over, even if you get convicted, you'll get it back. They don't want the money's not to keep for the government; it's just to make sure you show up. So if you're acquitted or found not guilty, you get your money back. If you resolve your case and the proceedings are over, you get your money back. The whole $35,000 Johnny A gets back. Or, I don't remember. Or, let's say it's a third-degree assault. Because in New Jersey, you don't have this option for second and first degrees. It's a third-degree assault where there's you cause or you intend to cause what we call significant bodily injury. Second degree is serious bodily injury. Again, words, right? Third degree, Johnny A, $35,000. But I'm going to let Johnny A put up 10%. So after that bit of judicial sorcery, he's only got to put up $3,500, but he's on the hook for $35,000. So he's only got to put up 10%. Now, what's the difference between that and having the judge simply set the bail at $3,500? Well, let's say Johnny A runs. Then he's on the hook for $35,000. When they catch him, then they'll file a lien against his home or put a judgment on him for $35,000. He's on the hook for the whole 35, but we'll take 3,500. But you're on the hook for, so between that and the guy who only puts 3,500 down, there's more of incentive to come back if you run and you lose 35,000. But you will have to have been the kind of person who will ever see 35,000 in your life for it to matter. But that's the theory behind it. The bail is 35,000 with 10%. Okay. So the Johnny A goes to the clerk. He pays 3,500. If he runs, he's on the hook for 35,000. If he does everything that's expected of him, he gets his 3,500 back. Case over. Same guy, Johnny A, gets charged with second-degree sexual assault. We'll call it. Doesn't really matter. Comes to court. Judge says this is a serious offense. You don't have ties to the community. You're a renter. You've got a criminal record. Bail's $100,000. Johnny A's not happy. It's a cash bail. No 10%. What are Johnny A's options? Only in America. There's a whole profession here where people lend people money to get out of jail. Bondsman. And you may see the word surety. We saw an unnecessary surety somewhere. That's what bondsmen do. They call that a surety. They sign a contract with the court to put the money up on behalf of Johnny A. But they don't do it for free. They're businessmen and women. And these businessmen and women, they want a fee. And the fee, this is what's confusing sometimes for students and lay people. The fee is typically 10%. So Johnny A, in my last example, goes to a bondswoman, pays her $10,000. The bondswoman goes to the court, gives them $100,000 on behalf of Johnny A. So it only cost Johnny A 10 grand, but guess what? He ain't getting that money back. That money's gone. That's the fee. That's the fee for the bail bondsman to put up the money with the court. If he flees, the bail bondsman's on the hook for the 100 grand. That's why they had the show on Bravo, The Dog. The dog was a bounty hunter. That's what the dog did. Looked for people who had ran away. And that's why the dog would be like, here's 20 grand. That's a lot of money to go look for a guy, and he's kind of in this general neighborhood, but he's on the hook for 100 grand. He's happy to pay the 20 grand. He already got 10 grand from the guy. So you're only losing 10 grand instead of 100. Now, interestingly, I never knew this until the middle of my career or even later. The bondsmen don't even put up a penny with the court. They run around promising stuff. It's a promise to pay. And they're not even on the hook. They have insurance. There's a whole branch of insurance that bondsmen pay for if the guy runs, the insurer will pay back the bondsman. But guess what? It's the end of the line somewhere. The insurer then hires the dog. Somebody's out 100 grand. But it may not be the bondsman. The bondsman hedges their bets by paying an insurance company for flight risk insurance. And this ain't when you get on a plane at Newark Airport. This is if the guy runs. So they hedge their bets. But at the end of the day, somebody's out big bucks. And they'll go look. They'll go look.
That's a dangerous job.
So let's review real quick. Types of bail. ROR, released on recognizance. Promise to show up, no money changes hands. Got it? Straight bail. Straight bail. $35,000, you drop off a check to the court, you come back, you get your check back at the end of your money back at the end of the proceedings. Right? 10% bail. Court orders $35,000, but we'll let you put up 10% of it. You don't show up, you owe the full freight. You do show up to court, you get your $3,500 back. Defense lawyers love that, because that money typically went right from the court clerk to the defense lawyer, because there's money in the bank. No matter how poor, no matter how broke, no matter how destitute, no matter what your position in life is, when you get locked up in jail, you find money.
You want to get out.
You come up with the money. Not everybody, that's a simplification, but people come up with some money, sometimes enough money. And that money's old money by the time the case is over. It's 3 years later, and the lawyer's there. I'll take that. From the clerk, to the defendant, to the lawyer. But if there's no 10%, there's nothing to get back. If your client, your defense lawyer, went to a bondsman, and that's the last one, bondsman, you don't get your money back. You pay a fee, they put up the money, case is over, you're out to 10 grand or 3,500 or whatever the 10% is. The bondsman gets their promise ripped up, case over, nothing for the lawyer to take, because the money was paid to the bondsperson. And bail's not for lawyers' benefits, it just happens to have the potential sometimes, when the client gets the money back, to pay some of the lawyer's fee. So ROR, straight bail, 10% bail, and bondsman. By the way, not all bonds people charge 10%. They can negotiate. If your bail is, $500,000, they may take 5%. They may take less. And they run a credit check, and they check references. They look for collateral. If you're some bum who's not likely to pay, they do the same kind of thing the court does. They want to make sure that you're going to show up, because they're on the hook for the 90% or more. But bail serves other purposes. The court wants to know that you're going to be on the straight and narrow while you're waiting for trial. They can attach conditions to the bail, especially in victim crimes. They will issue an order that is attached with the bail. The bail is $35,000, and I'm ordering the following. And it lives with the bail. It's attached to the bail. No victim contact. That means you stay away from the victim and the family. No victim contact, and no contact with the victim's mother. No, I have a case where things happened at a particular synagogue. You're not allowed to go to that synagogue. Go to another one. Why? Because the victim's family worships there. And they're not going to be, prejudiced by what happened. You've got to find somewhere else to go. No drugs or alcohol. Now, drugs are illegal, but no alcohol. Another condition might be drug testing. If you're charged with narcotics offenses, periodic drug testing might be a condition of bail. Tell me some other conditions that you may be aware of. Any ideas what other conditions that judges might attach to people's liberty? They may place you on home detention, where you're not allowed to leave the home. They may put a wad on your ankle. Lindsay Lohan dances through the night with micro mini skirts on, and 7 color different hair, and 500 cigarettes. And what's on her ankle? Come on, what's around Lindsay's ankle? You guys don't follow OMG on Yahoo?
It's an alcohol detector.
I don't know. I'm teasing. I don't know what she's got. She was on a bracelet. It's a bracelet. They have a GPS-enabled bracelet. And they have fancy alcohol things now, too. I'm not sure what hers is. But many people are released on bail these days, provided they wear an ankle bracelet that has global positioning satellite chip in it, which means we know where you are. And like every hour it beeps. It doesn't beep literally, it could, but every hour there's software and you see where the person is to keep a tab on. So condition of release might be you wear an ankle bracelet. And they're getting cheaper and cheaper and easier to use. Like 20 years ago, you didn't even have that. 10 years ago they had it, but it was expensive and they still had a few, and They'd only use it in the most serious cases. Now you can buy probably 100 of them for $1,000 or something. So that's another thing. A condition might wear an ankle bracelet, or might have to, you can get real creative, right? Somebody mentioned alcohol. They have a thing you've got to blow into to start your car. They've got all kind of technology now to do different things. And you see that up there on the board, where it authorizes the court to permit imposing restrictions on contact. But that's just one example of conditions of bail. No victim contact, stay out of high drug areas, not allowed to drink, drug and alcohol testing, wear an ankle bracelet, anything that keeps the community or yourself protected.
Nope, it's freezing. It's winter in here too. It's conditional form.
All right, let's take a look at the legal system, generally speaking. We looked at bail, and bail is part of the overall process of arrest and prosecution. But let's take a look at the players. And I mentioned them throughout the bail discussion. In the United States, and also in New Jersey, you have civil courts and criminal courts. Among the civil courts are the Family Division, Chancery Division, and the General Civil Division. Now, the civil courts, the general civil courts, tend to adjudicate or listen to cases that involve some conflict where the person who suffered a loss can be paid back in money. Car accidents, medical malpractice, right? Breach of contract. Somebody has a contract, they're supposed to put in a built-in pool, they put in a built-in pool, the pool collapses, they cause $20,000 worth of damage, you can sue for money. Somebody gets in a car accident, your car's destroyed, your MacBook is crushed, someone was negligent, you sue for the value of your MacBook, for your car. You can compensate the person who suffered a loss based upon the negligence or intentional behavior of another with money. You can make them whole again or address their injuries with money. Courts of equity, or chancery courts, I called it a chancery court. They also call them courts of equity. Cases go to courts of equity when you can't pay back somebody in money. Where money is not the outcome that makes the victim get what they want or need. One of the famous cases that made me understand a little bit about what these kinds of chancery courts do was, and I may be getting the facts a little bit wrong, but there was a time where Dr. Martin Luther King wanted to march for civil justice in the 60s in the South somewhere. It may have been Alabama, Mississippi, I don't know where, but he wanted to march and say a speech. And they wouldn't issue a permit. He needed a permit to march. And he wanted to march on a particular day. Let's say it was a meaningful day in American history, 4th of July. He wanted to march on the 4th of July. That's when he wanted to march. And he went to the city, and they refused to issue a parade permit. Now, the parade was going to happen in 10 days. Dr. King's lawyers went to court to get an order directing that the government issue a parade permit. Now, the government, whatever town or city it was, they came in and said, we don't have to issue a parade permit. The issue wasn't about money. The issue was about marching on July 4th and being heard. Because that's what he wanted to do. No amount of money would do what he wanted. He wanted to march. That's what he wanted to do. You can give him $1 billion. It doesn't solve the problem. The problem is we want to march on July 4th. So you went to a court of equity or a chancery court. Those courts tell people what to do or what not to do. They can issue restraining orders to restrain someone from doing something, or they can issue an order telling someone to do something. But it's not about money. Now, the family courts are more like courts of equity or chancery courts in that they handle family issues and matrimonial cases. It's not always about money. It's about who gets custody of a child, whether a marriage is going to be dissolved, those kinds of issues, right? The family division. Whether someone's parenting rights are going to be terminated, excuse me, whether there's abuse and neglect and the parent has to be monitored or has to follow certain requirements in order to keep the children safe. We know that's the family court. And then there's the criminal courts. And the criminal courts have jurisdiction over cases where there are violations of the criminal law. Let's focus on the criminal courts, although the process is similar with all 4 courts I described. Civil, chancery, family, criminal. Each one of those courts handle cases that arise before them because of a conflict between 2 or more parties. Each one of those courts handle cases where it's something or someone versus something or someone else. By definition, courts handle conflicts. It's not mediation. People aren't going to get together and try to solve issues. It's adversarial by definition. And people get into the courtroom, in whatever court you're in, because there's a conflict. And the people can't work it out on their own. In the criminal courts, it's a conflict between the state of New Jersey, the people of New Jersey, and the person who committed a crime. So it's state versus Facillo. In the civil courts, it's a private conflict. Let's say Facillo was suing Madonia, and it was a contract dispute. It's Facillo versus Madonia. Those are the litigants. If Facillo says, not only did Madonia break the contract we had to excavate dirt from his property, he also committed fraud in the amount of $10,000. He claimed to have a check that was worth $10,000. He gave me the check. It was worthless. He didn't even have a bank account. He did it on purpose. It was a theft by deception. So Facillo sues Madonia for the breach of contract in civil court, and then a criminal complaint is filed against Madonia for theft by deception. The name of that case is, again, State versus Madonia. Facillo versus Madonia, private parties litigate against each other. In the criminal law, the adversarial posture is the government versus a person or persons. State versus Madonia. The word state representing us, the collective. All of us have an interest in people not shooting other people, breaking jewelry store windows, setting fires. You know, we all have an interest in that. When somebody does that, we collectively, through our representatives and through our courts, go after them to punish them and to keep us safe. So it's state versus Madonia. In Canada, it's the Crown versus. In England, it used to be Regina versus Dudley. It's a famous case that we studied in law school. Someone know what Regina means?
Regina Victoria Regina is based on the Queen.
Correct. The Queen versus Dudley. Again, the Queen representing the collective, who's us in England if we're English, just like the state. In California, the case was the people versus O.J. Simpson. People versus O.J. New Jersey, it's state versus Madonia. In New Zealand and in the countries that still have a monarchy, and Canada are still frame their laws in terms of monarchical rule, it's Regina or the Crown versus the person. The point is, it's the government versus the person. And in those proceedings, in the criminal courts, when it's state versus Madonia, there's a trial. And if we're trying to prove murder and endangering the welfare of a child, let's say it's state versus Galloway. Galloway says, as I said earlier, I didn't do it, the confession was coerced. I have other witnesses to show that I didn't touch the child. There's going to be a trial. We all know what a trial looks like. The government has to put their witnesses on. The government in New Jersey has to prove their case beyond a reasonable doubt. It's a very strict standard. The jury has to be persuaded, as some have suggested, to a moral certainty. You really, really got to believe in your heart he's guilty. You don't have to be 100% sure. That's what, I've tried a lot of cases, and I got to communicate to jurors. Listen, you don't have to be 100% sure. We might as well go home. Nobody's 100% sure of anything. But you have to be convinced that this person's guilty, beyond a reasonable doubt. That's called the standard of proof. So in a criminal trial, State versus Galloway, the jury had to conclude that they were convinced beyond a reasonable doubt that he intentionally shook that baby to death. And beyond a reasonable doubt, he was the caregiver of that baby or assumed responsibility for the care of that baby beyond a reasonable doubt. That's the standard of proof. The state has to prove their case. The defense doesn't have to do anything. They could walk into the courtroom and text message, turn their back to the jury. I wouldn't recommend that, but you could turn your back to the jury. They don't even have to come to court. They could waive their presence. The burden is on the government throughout these United States to prove someone guilty beyond a reasonable doubt. End of issue. The defense cannot be called to the witness stand by the government. The government cannot say, well, you know what? When we arrested him, he didn't want to talk to us at all. We asked him if he did it. He said, I'm not talking. We can't even say, he must be hiding something. Why wouldn't he want to tell what happened? The baby's dead. Normal people would want to tell us what happened. He must be one who did it. You can't even comment that he didn't say anything. You're not allowed to talk about anything that Galloway said or did. Unless he did talk. In that case, he talked. He denied he talked, but he talked. But if he did talk, if the cops came and said, what happened to the baby here? I'm not answering your questions. I understand my 5th and 6th Amendment rights. I'm not doing it. Not saying a word. Guess what? Can't use that again. Can't even mention it. Now, at the end of the case, the defense lawyers often have to answer this question. Because the judge has to tell the jury what the rules are for a trial. All right, ladies and gentlemen, you heard from a number of witnesses in this case. You heard from Dr. Julia DeBellis from the Audrey Hepburn Children's House. She explained how she evaluated the child upon entry to the hospital. The child was still alive at the time. And then later how she reviewed all of the reports and how she collaborated with the ophthalmologist, how she collaborated with the radiologist, and how she concluded that these injuries were the result of certain kinds of injuries. You heard from Detective so-and-so who said that Mr. Galloway said this, that, the other thing. You heard from all these witnesses. You have to be satisfied beyond a reasonable doubt that Anthony Galloway intentionally assaulted little child with the intent that that child die. In order to figure out intent, you have to conclude, based upon the things that the person said, or the circumstances surrounding the death, that he did it on purpose. We decide whether people do things on purpose in a variety of ways. So the court gives instructions. They tell the jury how to figure this case out, right? Or what kind of things they need to think about. One of the things that defense lawyers have to say is to the judge will go, hey, defense lawyer, Galloway, let's assume Galloway didn't speak. He said, I don't want to talk. I'm invoking the Fifth Amendment. Don't want to talk. So the government can't mention, talk, infer, nothing about that. But the jury's not stupid. They go back there and go, how come we didn't hear from Galloway? How come he didn't take the stand? Galloway's got to make the $1 million decision. He's got to say, Judge, I want you to tell the jury that I made a conscious decision not to testify, and they can't hold that against me. They can't go back there and say, you know what? He didn't take the stand. We never heard his side. Screw him. He must be guilty. Galloway could say, I want an instruction that says something like that. Obviously, far better than I said it. Or, a lot of guys don't want any instruction because they think it highlights the fact that they didn't take the stand. Some lawyers go, we don't want the instruction. We don't even want you to. Because that's a double-edged sword, right? Because the instruction will go like this. Now, ladies and gentlemen, you heard a lot of witnesses in this case. One of the witnesses that you did not hear from was the defendant, Anthony Galloway. He did not testify in this case. Yeah, that's right. Why not? Well, he has a constitutional right not to testify. And you cannot go back in that jury room and say, you know what, Mr. Galloway didn't testify. Therefore, he must be hiding something or he must be guilty. You cannot use in any way, shape, or form Mr. Galloway's lack of testimony in this case as negatively impacting him in any way, shape, blah, blah, blah. A lot of defense lawyers don't like that because it kind of focuses on the fact that Galloway didn't take the stand. Even though the judge is yelling at the jury not to take that into account. Human nature is such that they may not follow that instruction. Guts. So, at the end of the case, the jury makes a decision. And they either convict or acquit. They convict him on some, acquit on other things. There's a decision. If Galloway's found not guilty, the case is over forever, for all time. Galloway could walk out of the courtroom and go, hey, check it out, jurors. There's a video of me killing a child. Guess what? Case over, man. Galloway beat the wheel. You cannot prosecute someone anew. It's in the Constitution, and it's called the rule against double jeopardy. No one can be tried again for the same crime. But if Galloway did that, then the feds would come in, and they'd charge him with human rights violations. Because it ain't the same crime, and they charge him with violating the little child's human rights. But that's different. You can't be prosecuted for murder. Case over. On the other hand, if he's convicted, then he can appeal. Now, the appellate courts, and every court has an appellate court. The civil courts I talked about, the courts of chancery, the family division, and the criminal courts. Once any of those cases are over, if it was litigated, they can appeal and ask a higher court to look over the trial. And there's a difference between the appellate courts and the criminal courts when it comes to appellate review. The appellate court does not decide whether Galloway's guilty or innocent. It doesn't say to itself, oh, let's see, I'm not so sure that he admitted everything. There was some evidence that I didn't agree with, one judge might say. They do not decide the facts again. Facts are done. Appellate courts simply look for mistakes of law. mistakes of law. During the criminal trial, before there is a conviction or an acquittal, the judge has to make a lot of decisions. Remember, Galloway made a statement. Galloway argued that that statement was involuntary, and even though he was read his Miranda rights, they weren't read to him properly. The judge listened to that testimony and came to a conclusion. There was also evidence in the Galloway case by doctors, I'm sure. Supposing the doctor said, my diagnosis is shaken infant impact syndrome, and she based part of that diagnosis on the fact that Galloway smacked another child, and that was in the DIFUS records when he was living with a different woman. Simply smacked the child in the face. There was a CPS investigation, and there was a substantiated physical abuse case. Not this case, some other case. And the doctor mentioned that in her testimony. And the prosecutor said, I want to put the DIFUS worker who investigated that case on the stand. Galloway's lawyers almost flew out of the courtroom. Their heads almost exploded. We don't want that in, Judge. That's not relevant to what happened here. The prosecutor said, yes, it is. It helps show similar behavior, and under Rule 404B, similar behavior is admissible. The defense says, not always, Judge, and not in this case. It has to be strikingly similar, and it has to prove something that the prosecutor can't otherwise prove. The judge says, man, this is a lot of work, this judge job. Man, I kissed all the senators' butts to get this job, man. So much work. I'm going to think about that. Court's adjourned for the day. I'm going to research the law. Judge goes home. Judge comes in the next day and says, I'm going to make my ruling. I've read Rule 404B. I've listened to the arguments of counsel, both of whom are learned and expert attorneys. My compliments to both sides. I am going to let the DIFUS worker testify. And here's why. Blah, blah, blah. Okay? That happens. Now the statement got in, right? The DIFUS worker's testimony got in. The prosecutor wants to put in Galloway's prior history. Now you're allowed to put in someone's prior history, but if it's similar to the case on trial, the judge may have to, what they call, sanitize it. Without getting into that, the judge allows evidence that Galloway was arrested for simple assault, rather aggravated assault when he was 22, and he was convicted, and he spent 6 months in jail. Another command decision by the judge. And throughout the trial, judges make lots of decisions. All day, each and every day of the trial. Judge, I object. That's a leading question. It's not leading. I'll allow the question. Boom. There's another issue, right? Judge made a decision. I gave you some big decisions. Miranda, whether the statement comes in, right? Another big decision. Whether the statement of the doctor and the DIFUS worker about the prior substantiated abuse comes in. Big deal, right? Criminal record comes in. But judges make decisions from 9 till 5 throughout the trial. Many of them are not significant, but they all are capable of being scrutinized by an appellate court. That's what appellate courts do. It goes to the higher court, they're going to decide whether the trial judge was right in letting in the defendant's statement, or should it have been prohibited, right? Because his rights were violated. The appellate court's going to look at whether the trial judge was correct in allowing the prior substantiated DIFUS case in. Right? Because the trial judge made a decision. Appellate court doesn't decide whether Galloway's guilty or innocent. Got it? They simply see whether the trial judge made mistakes of law. Mistakes of law, letting in the confession when it shouldn't have come in. Letting in the prior DIFUS issue when it shouldn't come in. Letting in the prior criminal record when it shouldn't have come in. Conversely, if the prosecutor wanted the criminal record in, or the DIFUS record in, and the judge wouldn't let it in, if there's a conviction, the prosecution can appeal. Judge, if this has to be retried or it's reversed, we want to get it in next time. That judge was wrong. Again, they don't decide Galloway's guilt or innocence. They decide whether the judge made mistakes during the trial of Galloway. And judges make decisions 9-5 during the trial. And every one of those decisions can be appealed and are scrutinized by the appellate court. Because the trial judge is like a referee. They are a filter, a human filter that filters evidence. And evidence is what convicts people. Evidence is what convicts people. So, depending upon whether certain evidence came in or not, Galloway might have had a different outcome, right? And that gets to the next issue. Judges make mistakes every day of the trial, 9-5. Not every mistake's a big deal. Even if the appellate court concludes that his criminal record about the bar fight when he was 21 shouldn't have been admitted, the mistake, listen closely, folks, the mistake has to have had the capacity to change the outcome. You follow? It's got to be a big mistake. You've got to be able to say, Judge, if the jury never heard that I got in a bar fight when I was 21, I wouldn't have been convicted, man. That prejudiced them against me. If they didn't hear that, they would have acquitted me. The result would have been different. You need to not only show mistakes that the judge made, but also that the outcome would have been different. Appellate courts, week after week, say, you know what, the judge did this wrong, but did that wrong, but it didn't have the capacity to change the outcome. So they get the message to the lower court, better not do that again, but we're going to let the conviction stand. Now, we're trying a case right now. My colleague, Chris Freed, who teaches in this program, is trying a case right now where a developmentally disabled girl, 8 or 9 years old, maybe a little older, 10, under 12, reported that the defendant, it might have been her uncle, had performed cunnilingus on her, right? Oral stimulation of the vagina, licked her vagina. Now, she made a disclosure. She's going to come to court and say it happened. She had incontinence, so she had a diaper she wore. And the diaper was seized at the time of the disclosure that she wore at or about the last time he did this to her, allegedly, and sent to the state police lab. We're trying to see if there's any DNA, any residual, any forensic evidence. It turns out that we couldn't get DNA. Did I tell you the story already? Mm-hmm. We couldn't get DNA because there's a property of diapers. The modern diaper has chemicals in it to make it super absorbent. It also kills DNA. So the chemical properties of the modern diaper killed the DNA. However, they were able to get a sample of some kind of fluid on there that wasn't part of the diaper that had a high concentration of an enzyme, a digestive enzyme called amylase, A-M-Y-L-S-E, amylase. And there's all kind of research that says that the only bodily fluid that has this concentration of amylase is saliva. Now, that's not to say that it's not in other bodily fluids. We know it is. It's in pancreatic secretions, it's in urine, it's in vaginal secretions, but in very low concentrations. So if you look at parts per million, I'm making this up. At least the numbers, not the concept. In those other secretions, vaginal, pancreatic, urine, and all that, you'd find 500 parts per million of amylase. In saliva, it's 100,000 per million. It's so different that it's saliva. Judge won't let it in. Well, I'm not. The guy wasn't 100%. The scientists refused to say it was saliva. He just said it was consistent with saliva. Okay. Now, you don't have to say it was saliva. We're appealing her, the judge. Now, this is an appeal in the middle of trial. Prosecutors have to appeal in the middle of trial because if he's acquitted, we can't then appeal because it's double jeopardy. Case is over. So when we have an issue we really feel strongly about, we got to appeal now. And we have to ask the court's permission to appeal. The very judge who made the decision. Most of them, I don't think she denied it, but she could have, and then we'd have to appeal her denial of our request to appeal. So we appeal the denial of the request to appeal, and this is a big issue. I mean, this is what it's all about here. We got a girl statement, we got corroboration. She said it's a licking case, we got saliva in her pamper. So it's a big deal, and we're in the process of appealing that now. But that's a little bit different. So the prosecution's appeal posture is different. The defendant has to typically wait till the case is over. Because the judges don't want to decide things if they don't have to. The guy's acquitted. Appellate division doesn't have to work on that case. Next case. So you see the difference between the trial court and the appellate court? They don't decide whether the guy molested the girl with the pamper. That's the jury's function. They simply make sure that the judge made the correct decisions below and the trial was fair. And as the gatekeeper, they let in the evidence that should have come in and they kept out the evidence that shouldn't have come in. Nearly all appeals are based upon the admissibility of evidence and its potential to change the outcome or the verdict. Again, the court's not going to reverse a case unless it had the capacity to change the outcome. So what happens? Let's say Galloway wins. Galloway says, my Miranda should have come in, my barroom fight, the diaper stuff. Well, the Miranda should have come in. We agree with the judge. We also agree with the judge that the barroom fight was okay to come in because it was sanitized properly. But the DIFUS substantiated finding had the capacity to change the verdict. In our judgment, he may have been acquitted if they didn't hear that. It would be very difficult for the jury to not conclude he's a bad guy, the kind of guy who hits kids, and want to punish him even though the case on the Jacob baby was weak. You know, the prosecution didn't have the strongest case, but now that they know he's a two-time guy who hits kids, they might have decided, we just can't be sure, and we got to believe, we're going back. So what's the outcome? The conviction is reversed, it's erased, it's sent back to the trial court. Galloway walks back in the courtroom next time in exactly the same posture he was the day after he was arrested. Do-over. When I was a kid, something went wrong, a car came and you couldn't throw the pass accurately, you're playing street football. Do-over. It's a do-over. Do-over. That's where there's a reversal. And you start over. And the judge has got to make the same decisions. In fact, the case that Chris Freed's trying about the diaper and the amylase is a do-over for a different reason. At the end of the state's case and the defense, when the case is over, the jury has to agree unanimously in New Jersey. We require unanimous verdicts in criminal cases. So all 12 people have to agree. And then there's a conviction. If one person or more cannot agree with the rest, and after a reasonable amount of time for them to change their position, the judge declares what's called a mistrial. And then you get a do-over again for different reasons. Chris had a mistrial in the first case. Do-over. And he's nothing worse than a child abuse case for a do-over. But
Considered a reasonable amount of time.
well, it all depends upon the complexity of the trial, what's happened so far. But usually, the jurors, if they say they're deadlocked, 2 or 3 days, maybe 4 days, depends on how much is invested in the trial. They'll ask them over and over if more time will help, and usually by then they'll be like, no, that's why we're coming to you in the first place. Well, go back. If you think your decision is wrong, you still have to consider others. Don't be pig-headed. Get back in there. But I've never seen one go for more than a week. In the trial itself, the prosecution has the burden of proof. I told you that. And they go first. They have something called an opening statement. Good afternoon, ladies and gentlemen. My name is Joe Del Russo. I'm the chief assistant prosecutor in this case. And that man back there, in the summer, August of 1996, he hit himself on High Mountain Road near a filter plant down in the bushes. And a woman named Jody was jogging by that day, but she'll tell you she wasn't jogging at all, she was running. She was training for the Olympics, and she would run every day between 6 and 7:30 along High Mountain Road. Sometimes she put in 12 miles. Many days she put in between 15 or 20 miles. But on this day, on this 90-degree day in August of 1996, Joe Loggins grabbed her around the throat, dragged her into the woods. She began screaming. Now, there were college girls who lived in a sorority house about a quarter-mile away, and they heard her screams. She got it in her head that you're supposed to yell fire instead of rape. She read it somewhere. The girls heard the screams, and they thought she was yelling liar, or some woman or girl was having a fight with her boyfriend, and they didn't come and help her. So Mr. Lodmans began to rip off her clothes. And should you tell your story? And it's got to be based upon the facts. It's got to be based upon the evidence. And try to tell it as persuasively and compellingly as you can, because there's theories among public speakers that people remember the first thing best and the last thing best. One thing that's advantageous for prosecutors is they go first and last. They tell their size, they size up the evidence for the jury, and then the defense